Your landlord's dog bites you while you're delivering a package, and suddenly you're stuck in a legal maze nobody warned you about. The law actually splits visitors into different categories, and which one you fall into can make or break your entire injury claim. Trespassers get the short end of the stick almost every time. If you sneak onto someone's property without permission, the property owner usually only has to avoid intentionally harming you, nothing more. A licensee is someone who's there with permission but for their own purposes, like a friend coming over for dinner or a neighbor borrowing a ladder. Property owners owe licensees a duty to warn about known dangers, but they don't have to go hunting for hidden hazards just for you. Then there's the invitee, the golden child of premises liability, like a customer at a store or a guest at a paid event. Property owners owe invitees the highest duty of care, which means actively inspecting for dangers and fixing or warning about anything risky. Here's where it gets messy though, because some states have ditched these three categories entirely and just use one reasonable care standard for everybody. Texas, for example, still leans heavily on the traditional categories, so where the injury happens seriously changes your odds. Picture two neighbors, one invited over for a barbecue and one sneaking in the skateboard on the empty pool deck. If both get hurt on the same crumbling step, the invited guest probably has a strong case while the skateboarder might walk away with nothing. This is why lawyers spend so much time figuring out your legal status before they even talk settlement numbers. Were you invited? Were you tolerated? Or were you somewhere you absolutely should not have been? Because that single detail can shift a case from a slam dunk to a dead end. There is a twist called the attractive nuisance doctrine, and it mostly protects kids. If a property has something like an unfenced pool or an old trampoline that practically begs a child to wander in, courts often hold the owner responsible even if that child was technically trespassing. A lot of people assume getting hurt anywhere automatically means a payout, and that is one of the biggest misunderstandings out there. The law cares less about your pain in the moment and more about your legal relationship to the property when the pain happened. Insurance companies know these category rules inside and out, and they will use them against you immediately. They might argue you were a trespasser even if you genuinely believed you had permission, just to shrink or kill your claim. This is exactly why documentation matters so much, like texts, invitations, or witnesses who can confirm you were supposed to be there. The difference between licensee and invitee sometimes comes down to one text message that says, "Come on over." Some states blend the lines further with comparative negligence, where your own carelessness gets weighed against the property owner's failures. So even a trespasser might get a small percentage of compensation if the property was egregiously dangerous, while an invitee can lose money if they were busy staring at their phone instead of watching where they walked. History actually shaped these rules since old property law was built around protecting landowners above almost everyone else. Modern courts have slowly shifted toward fairness, but plenty of these old bones are still holding up the system today. The smartest thing you can do after any injury on someone else's property is to figure out your status before you say a single word to an insurance adjuster. One wrong assumption about being a guest instead of a trespasser, or vice versa, can quietly tank your entire case before it even starts. So next time you hear about someone getting hurt on someone else's land, remember it is never as simple as good guy versus bad guy. It is trespasser versus licensee versus invitee duking it out in legal trivia. Want to learn more about how this could affect your situation? Check out our links in the description.